Derek Chauvin, day 25. We've already been following this case in depth for some period of time now, and today was a critical day for the defense because Eric Nelson put on the stand Dr. Fowler. Dr. Fowler is a forensic pathologist, so we heard from him all day, literally all day. He was the only witness that we had today, and so we want to break down what was said. What is his interpretation? Because this is the counterbalance to all of the evidence that we heard from the prosecution up until this point in time. So as we always do, let's go to our trial board and see where we're at. This time today, we're in the defense case now. They're presenting their evidence. And so we heard all day today, of course, Eric Nelson. We had some questioning, some cross-examination from Mr. Blackwell later this afternoon after the direct examination was over. And we also heard a little bit, I think it was from Matthew Frank, or it might have been Steve Schlusser this morning. I don't recall. I think it was Steve Schlusser. Not a lot from the prosecution today because it's the defense case, right? They're just out cross-examining. They're not calling witnesses or anything like that. We did hear from Adrienne Cousins, who is the public defender for Morries Hall. And so we got to break down what happened there because there was a lot of question about whether Maurice Hall was going to be called in to testify, given the fact that he was a passenger in George Floyd's vehicle back on May 25th. So a lot of sort of back and forth about that. Is he going to come in and testify, or is this going to be a missing gap in the case? Because obviously we know that the jurors have some idea that there is an individual because they saw Chang's body camera video and all of that. So we're going to get into that. Let's take a look at the witness list for the defense. As we saw yesterday, we had a lot of people, 6 people yesterday. Today, only one, Dr. Fowler, who is from forensic pathology. This is the government's sort of partial witness list. Didn't hear from anybody or see anything on their side of the aisle today. And so we are going to start off with what happened before testimony started. So Dr. Fowler, of course, was the primary witness, the only witness all day long. But there were some pretty important things that happened before the day kicked off. And so first and foremost, you may have seen this news sort of spreading around yesterday that Eric Nelson was going to be moving for a judgment of acquittal, right? It's sort of, oh my gosh, he's going to move for acquittal right now. Are you kidding me? Is this, what's happening? This is pretty routine, right? This is pretty standard stuff. So after the government rests their case, the defense will typically file one of these motions. It's just a procedural thing. It's saying, listen, we've heard all the government's evidence. They haven't even proven their case. We don't even have to present a defense based on the garbage that they showed us in court today. Nothing that they said could ever possibly lead to a conviction. Therefore, we just, as a matter of procedure, move for a judgment of acquittal. And that's exactly what happened today. So it wasn't even a big deal. Many people were sort of tweeting this on Twitter going, oh, motion for acquittal. What's happening? Like this is some big thing that was going on. No, it really wasn't. And it got about that much time in court this morning. Eric Nelson came back out and said, yep, Judge, we're moving for an acquittal. Here's why. Government experts are, disagreeing with one another. And he went through a couple of examples. He said he was basically diving into the use of force analysis. We saw that Sergeant Steiger was disagreeing with the law professor who we heard from, the government's last witness. They sort of had disagreements about the prone position and how some of that worked. So there was some points of contention there. Similarly, we saw some of the medical experts contradicting one another. There was some indication that, Dr. Tobin, for example, thought that the mechanism of death was asphyxia, low oxygen. We bring out Dr. Baker. Not really. He said his heart kind of gave out, caused by heart disease. So different causes. Eric Nelson comes back out and says, look, they don't even agree with themselves, for crying out loud. So how could we possibly be convicted as a result? But again, very formulaic. He didn't spend a lot of time in here. He just kind of ran through his questions, maybe 5 minutes, 6 minutes of argument, talked about the cause of death, experts contradicting themselves, all of that stuff. So then prosecution came out, presented their case. No, we think we did a good job. We met our burden. Judge says, yep, okay, good enough. There's enough here to move forward. The state has presented enough that we can hand this off to the jury, right? There's sort of a burden that the state has to meet in order for the case to move forward. So you challenge that. You say, yeah, they tried, they didn't do it. Judge said, okay, yeah, they did, which is almost always the case. So we knew that was going to happen. Not a big deal, but just wanted to clear that up. Second issue that is a bigger deal is the Morries Hall. Morries Hall now is the passenger, if you recall, who was also in the vehicle with George Floyd and Chauvin Cahill when the police approached the vehicle. So if you recall, those two individuals, Morries Hall and Chauvin Cahill, were pulled aside. They were dealt with by Officer Chang, who we recently saw his body camera video in court. And so he was attending to them so that they didn't get into the car, mess with evidence, or allow other people into the car. So he was sort of securing that portion of the scene while Chauvin and the others were dealing with George Floyd. And so the jurors saw that video. They know that Morries Hall is there. They know that we heard from Cahill. They know we heard from basically everybody else and their mother from the government's case. We heard from the firefighter. We heard from the passerby who was just walking down the street. So they may be asking themselves, where is Morries Hall? Where is this guy? We know he's there. Why haven't we heard from him? So today, they were trying to get him into court. Nelson filed a subpoena for him to come and testify. Morries Hall and his attorney moved to quash that subpoena. They basically said, we don't want to testify, and we're protected against being forced to testify pursuant to the Fifth Amendment. And so let's take a look at the judge today. This is Adrienne Cousins, who is the public defender assigned to Morries Hall. She's in court today, now basically making the argument to the court as to why Morries Hall cannot testify. Here it is.
Good morning, Your Honor. Adrienne Cousins and Jeff Isaacman appearing on behalf of Mr. Hall, who again is present in the courtroom. Your Honor, where we last left off at the last hearing was you had instructed defense counsel to submit a list of questions on a very narrow topic to see whether or not Mr. Hall could answer a very narrowly tailored set of questions and whether or not his Fifth Amendment privilege would be implicated in those questions. I've had a chance to review those questions, Judge. I've reviewed them with Mr. Hall. And to summarize, Mr. Hall cannot answer any of the questions that defense put forward. And I'm happy to expand on the reasons why he can't answer any of those questions.
Let's just focus on how Mr. Floyd looked in the SUV, because that was the very limited group of questions that I thought might not incriminate him.
Absolutely, Judge. And if you look at the list that defense proposed, I think that really starts getting into that topic at question 7. So question 7 proposed by the defense was, after conducting your business in Cup Foods, did you return to the vehicle with Mr. Floyd? Mr. Hall cannot answer that question. Mr. Hall cannot put himself in that car with Mr. Floyd. Again, this was a car that was searched twice and drugs were recovered twice. If Mr. Hall puts himself in that car, he exposes himself to constructive possession charges of the drugs that were found in that car. And it's important to note, Judge, that Mr. Hall exposes himself to that charge whether or not Mr. Chauvin is convicted or acquitted. Whatever happens with this case, the state can still come back and charge Mr. Hall with constructive possession of drugs in that car. So he can't put himself in that car.
Yeah, so, as a legal observer, I want to say, yeah, but we still want to hear from him. Hello. For the spectacle of it, we want to hear him come in. But legally, she's absolutely right? Anything that he says, anything that he does, the prosecution at this point in time has not given him any immunity. So if he says something that opens the door to criminal charges, he's on the hook for that. Chauvin's not. Judge isn't. This public defender isn't. The government has not offered him immunity. So he can't talk. Now, here is Morries Hall coming in and trying to explain or explaining why he wants to invoke. The judge kind of helps him along, as you'll see.
Good morning, sir.
Good morning.
You understand, Mr. Hall, you do have a Fifth Amendment right not to be compelled to incriminate yourself. Do you understand that?
Yes.
All right. And you understand that applies even when you are not one of the parties to the case, but when you're a witness in a trial. Do you understand that?
Yes.
You understand that your attorney, and I'm sure they have given you advice about whether to invoke your Fifth Amendment right against compelled self-incrimination. But ultimately, it's your choice. You understand that?
Yes, sir.
All right. And you'll have to speak up just a little bit, and I'll turn up the podium. There we go. You understand this is your choice, so you could disregard the advice of your attorneys if you wanted to.
Yes, sir.
Knowing all that, you've had a chance to look at the questions that were proposed by both sides?
I have.
Would you be willing to answer those if I were to put you on the stand and swear you in as a witness?
No, I am not.
Okay, and why would you not answer those?
I'm fearful of criminal charges going forward. I have open charges that's not settled yet of my personal stuff.
So basically, you are invoking your Fifth Amendment right against compelled self-incrimination?
Yes, sir.
All right, thank you, sir. You can have a seat.
All right, so it kind of nudges him along, right? Yeah, all right. And, the judge is even, I think, a little bit interested in hearing more. So the way that this worked is the judge gave Eric Nelson and the government, the prosecution, an opportunity to present a certain series of questions that they think would not be self-incrimination, that they could ask him. And of course, we heard the public defender just come out and said, no, basically any question is going to put him in the car. That alone is enough, which is a good argument. It's, it's sort of the right legal argument, even though many of us wanted to hear from him. Yeah, that's the right move. And the judge agrees. So here is Judge Cahill sort of explaining why this is, and then we'll break down what this means.
All right, I'm going to advise both sides to file your proposed questions as essentially an offer of proof on what you would have asked Mr. Hall. But I am finding that he has a complete Fifth Amendment privilege here. I had earlier said that possibly he could talk about how Mr. Floyd looked in the car, but counsel's argument is persuasive that that could provide a link. And since it's not just evidence that would incriminate a person, but also provide a link to incriminating evidence, I do find that his invocation of his Fifth Amendment rights is valid, and accordingly, I am going to quash the subpoena. Anything else? All right, thank you.
All right, so subpoena's quashed. Maurice Hall's not testifying. And Liberty or Death asked a great question about this over on locals.com, and he was asking essentially, did Nelson know about this? Was this part of the strategy? What does this mean? And I think that Eric Nelson probably realized that it was going to be difficult to put him on the stand and get any questions out of him just because of the fact that it would be self-incrimination. He's a defense lawyer. He knows that. But he still wanted to try because it would have been a very, very compelling spectacle. Literally, I use that word a lot today, but that's what it would have been, is to put him on the stand and have him re-invoke repeatedly. I've been advised on counsel to invoke my Fifth Amendment rights. Not going to answer that question over and over and over again. And the reason being is because the jurors are going to see that, right? And they're going to say, well, why is that guy on the stand not answering questions? We have all these questions in this case about what caused the death of George Floyd. We have expert witnesses who've been presented offering competing viewpoints, alternative interpretations. We have a guy here who's not answering any questions. Maybe he had something to do with it, right? You're sort of opening the door into that reasonable doubt argument. And so now they're not going to be able to do that. Now, do they lose anything? Does Eric Nelson and the Chauvin team lose anything? Not really. I think that it would have been only upside if they would have got Morries Hall in. But now that it's not, I'm not sure that they lose much. Remember, we still have Cahill, who testified that George Floyd was in the vehicle falling asleep several times. When I say we, it's from the defense perspective, right? The defense is making these motions. So they lost the motion, but do they lose anything really? Hill is going to still come in and testify that George Floyd was falling asleep in the vehicle, that there was sort of a radical change in mood from what she observed inside the store to outside the store. We also have the Chang video, so the jurors know that Maurice Hall was physically there. They know that he got out of the car. They saw a conversation about him, but that's it. So they can kind of piece together the dots or connect the dots, I think. That can say that if we know that there were pills in the car, we know that there was even pills in the back of the police car. We know that those tested positive for fentanyl. We know that George Floyd was falling asleep at the wheel. We know that the toxicology report came back, 11 nanograms per milliliter of fentanyl combined with some other remnants of methamphetamines and other drugs. And so the jury is now saying, all right, well, we know that we have sort of this chain that exists. There's a missing link here. Maurice Hall can fill that, but you can sort of, it's like circumstantial evidence, right? You can fill in the gaps on your own, and Eric Nelson did that. So that was it for that. We're not going to hear from Maurice Hall in this trial at all. This is somebody who is not going to be required to testify because Judge Cahill just quashed the subpoena. So then we change gears. Now, this is the big witness of the day. This is Dr. David Fowler, and he is from South America, got a little bit of a British accent going on, which is only upside, right? That's only good news. If you have an expert witness with a British accent and an expert witness with not a British accent, it's like kind of like game over. So major upside over here, kind of up on the points thus far because he has a British accent, which we're going to see. Big deal. Also, a retired person who does consulting, full-time forensic pathology. So now we're in the medical component of the case as we've been for some period of time. And it's really kind of the same thing that we've heard a lot of. They come out, they puff up their resumes. This guy has a very, very impressive resume, as you would expect. And he had a little bit of an interesting twist here. So he was the office of the chief medical examiner over in Maryland. He's licensed, credentialed, licensed doctor, tons of training, testified hundreds of times, done thousands of autopsies. It sounds like 800 a year were the number of homicides that he was reviewing when he was there. Tons of articles. And he's part of a couple of these organizations. One is called the Forensics Panel. So it sounds like this case was sort of almost peer reviewed. He's part of this organization that reviewed this case. So it's sort of like a meta expert witness. This guy's an expert. He's going to come in and testify, but he's going to explain the findings that he uncovered sort of in conjunction with a number of other expert witnesses, other forensic panelists who are on this panel. He said that there are 13 peer reviewers. So it's sort of like 13 people did their own analysis gave him some input on it and then prepped this guy to come in and testify in court. And he did a good job. And he was really fleshing out a lot of the same issues that we've already heard about. So what I want to do here is we're not going to go through the whole thing. It was like 7 hours, 7 hours of testimony today. All one guy, a lot of stuff, a lot of the same stuff we've already heard about. Things like use of force. Again, it's medical. So, did the force of the knee cause any medical repercussions and things of that nature? So I'm going to show you his conclusion first. Then we're going to go through and we're going to analyze a little bit of his testimony in conjunction with some of the cross-examination. We have some redirect some segments, and I think a recross segment as well. So a little bit of back and forth all day today. Nothing really groundbreaking, quite frankly. I thought that this was all relatively to be expected. We always knew that it was going to be sort of a battle of the experts, dueling experts. We've been saying for months on this channel that the government's going to just sort of throw a bunch of experts at it. The defense is going to throw a bunch of experts at it, and we're going to see what the jury decides, right? Because you can make the science say whatever you want. Whatever you want it to say, you just make it say that, because that's how this stuff works. There's a lot of room for interpretation. That's the nature of this stuff, right? It is not definitive, and so the government is going to try to come out and make it definitive. The defense is going to come out and say there's reasonable doubt about all this stuff, and so the jury is going to find ultimately where they stand, and we're going to all see that very, very soon, because closing arguments should be starting on Monday. So let's get into Dr. Fowler. And this is the first clip where he's talking about the ultimate conclusion. So we're going to get that first, and then we're going to kind of work backwards. And here is where he says that the basically why Floyd died is a result of sudden cardiac arrhythmia. Let's listen in and see what he has to say.
So before we begin, Doctor, can you summarize briefly what your opinions are in this case?
Yes. So in my opinion, Mr. Floyd had a sudden cardiac arrhythmia due to his atherosclerotic and hypertensive heart disease, or you can write that down multiple different ways, during his restraint and subdual by the police, or restraint by the police. And then his significant contributory conditions would be, since I've already put the heart disease in part 1, he would have the toxicology, the fentanyl and methamphetamine. There is exposure to a vehicle exhaust, so potentially carbon monoxide poisoning, or at least an effect from increased carbon monoxide in his bloodstream, and paraganglionoma, or the other natural disease process that he has. So all of those combined to cause Mr. Floyd's death.
All right.
So he largely agrees with Dr. Baker, right? Who said it was kind of the same thing, like his heart just gave out. Says it was heart disease. You heard him use the medical terms, arteriosclerosis, hypertension, blah, 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 all that stuff, right? But it was heart disease. Didn't hear anything about low oxygen, didn't hear anything about asphyxia, which is what the other government witnesses have been beating home, other than Dr. Baker, throughout the entire presentation of their case. So he does talk about fentanyl and meth, calling those contributing factors. And so really what he did is he went through the same medical certificate that Dr. Baker did, and agrees with those findings, says it was caused by sudden cardiac arrhythmia. Then he goes through and he spends a lot of time detailing what that is. What is cardiac arrhythmia? How does the heart work? And on and on and on. And he goes through a lot of the same analysis that we've already heard, right? Because if you recall, Dr. Baker's testimony, who actually performed the autopsy, said that he takes pictures and does his autopsies in a way that is so detailed that he can basically give his case file over to another pathologist or another somebody who does autopsies, and they can draw their own independent conclusions based on the work that he did. He takes many detailed pictures, essentially in the way that he would want to get a file if he were asked to independently review and certify that case. So that was happening here. He goes through, says he looked at everything, blah, 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 on and on and on, talks a lot about the heart and how the heart works, and about how you've got different, valves pumping, and if anything interferes with that, like if you have a heart valve or an artery that is 90% closed or 70% closed because of heart disease, you're going to run into some problems. And so a lot of testimony was about the mechanical functions of the heart and how all this stuff interfaces with itself in the context of heightened activity and increased workload, and on and on and on. So he goes through a lot of studies. He says, this study weighed all these hearts, and we know that a certain heart that weighs a certain amount is hypertensive, because of X, Y, and Z. So he's very, very masterful with the material. Definitely, obviously an expert, somebody who is well credentialed and has a grasp on what he's talking about. And so we're going to sort of move beyond some of the hard stuff a little bit. And I want to show you this clip where he's talking about the knee, right? So now we're talking about the placement of the knee and how that might impact vital structures in a person's body. We just heard from Dr. Tobin, who was the government's expert witness, who came out, gave us some very nice, beautiful graphs showing the physics, the weight. We had a picture of Derek Chauvin with his gear on, his body armor, his weight belt, his holster, his guns, and all of that stuff, and did some serious calculations and said, look, all of this weight, all of this pressure on the back of Floyd is going to necessarily cause him to not be able to breathe, which led to low oxygen, which resulted in death by asphyxia. So now we have this expert witness who comes in and basically says, there was a knee on the neck, but so what? Didn't do anything to any of his vital structures. You can't find any evidence based on what I reviewed that was the pictures from the autopsy that was conducted by Dr. Baker that shows any injuries to the muscles. There's no subcutaneous tears or tissue problems and no damage to any of the vital structures. Here it is in court today.
In terms of the placement of Officer Chauvin's, knee to Mr. Floyd, is it your opinion that Mr. Chauvin's knee in any way impacted the structures of Mr. Floyd's neck?
No, it did not. None of the vital structures were in the area where the knee appeared to be from the videos.
Now, again, in terms of your death investigations, you've reviewed photographs, you've reviewed the autopsy photographs, things of that nature, correct?
Yes.
Were any signs of, generally speaking, do signs of injury play into your analysis as to the cause of death?
Yes.
How so?
Well, you make an observation of, such as in this particular case, of a knee providing force to a particular part of the body, and then you go and you look at the same part of the body to see whether or not you can find corroborating evidence within the body itself, either an abrasion to the skin, subcutaneous hemorrhage into the muscles, or other injuries that may be caused by the knee.
And what injuries did you observe in the photographs of Mr. Floyd?
All of his injuries were in areas where the knee was not. In other words, they were on the front of his body, his face, his places where he was restrained, but there was absolutely no evidence of any injury on the skin to the subcutaneous tissue or the deeper structures of the back or the neck.
So if Dr. Tobin then is right, and there really is all of that pressure being localized on the back, one kind of small area on somebody's back or neck or whatever, then you would expect to see some associated bruising, some subcutaneous injuries, and so on. And he didn't see any of that. Now, that's one interpretation. Other doctors, as we've heard from the government, said, no, you shouldn't see anything. You shouldn't expect to see anything. And there's nothing to even note about that, right? There's nothing there. They're saying that the damage was sort of happening internally and then on the ground facing side. And so that would be my response to that. Well, all right, so you don't see anything on the back side of Floyd, on the back or neck area. There's no damage to that area of his body. But on the other side, where the face and the body were smashed against the pavement, he did have some injuries. So there must have been pressure, right, in order to cause those injuries. His response, I would guess, would probably be that no, those are not pressure injuries. Those are sort of body weight pressure injuries from somebody moving around. Yes, of course, there was pressure from the officers keeping him pinned to the pavement, but not anything that would structurally compromise the internals of a person's body, neck. Remember what we're talking about. We're talking about some physical sort of limitations on the body by Chauvin's neck. It was either collapsing the trachea, it was cutting off the arteries in the neck, it was causing something that was resulting in low oxygen or asphyxia. So mechanically, the knee was physically killing Floyd. He's coming out and saying, yeah, I mean, if you were to see that pressure, then you would expect to see some corroborating injuries. and I didn't. So then we have over here, we have the cross-examination. So they're talking about asphyxia. I believe in this clip, they're talking about asphyxia. And the cross-examiner, who is Jerry Blackwell, who's a prosecutor, comes back out and he brings up the big book, right? He holds up this big book. And so on cross-examination at this point in time, you know, Jerry Blackwell knows that this guy's an expert, knows he's very highly credentialed. And so what he's trying to do is now tease out some distinctions between his opinions and the opinions of other excellent people. All these other smart people, you just said something, but these smart people say something differently. So what's going on here? And, you know, that's kind of a double-edged sword from the prosecution's perspective, because, yeah, they're undermining him, this particular witness in this incident, by sort of pointing to other literature that has an alternative theory or explanation or opinion. But at the same time, you know, they're sort of showing that this is a reasonable way to create doubt, right? If they're going to take a look at Dr. Fowler and say, you have this opinion, these doctors have that opinion, and we want to raise these up and show you what a big stinking problem this is, doesn't really work out well for their case, because that's exactly what the defense is going to do. Hey, you just paraded these 3 witnesses, or these 6 witnesses, or these 3 use of force experts, or those medical examiners. You just puff them up. Well, we've got our own people, by the way, over here. We're going to puff them up, and there is a disagreement there. So the same technique that you used to undermine Dr. Fowler, we're going to use that right against you and say, yeah, it is appropriate to draw distinctions between expert witnesses, and they're going to do that. So, you know, it's a cross-examination technique, of course, but it can only carry you so far. Here it is.
Dr. Fowler, are you familiar with a text known as Spitz and Fisher?
Yes.
Pretty big. This is a standard text for medical examiners, isn't it?
It's certainly one of the recommended books that fellows in forensic pathology will review as part of their training, yes.
And it's one you've in the past referred to as reliable text.
Yes.
It is handed out to all forensic pathologists in training as just a standard text.
Again, it's recommended that they use that as one of their references.
And you're aware that this text on medical legal investigation of death, it contains sections on deaths by asphyxia, doesn't it?
Yes.
And do you agree that for death by positional asphyxia, that is death caused by low or insufficient oxygen, that the causes for that may be what's referred to as endless?
Yes. Hence the complexity of these particular cases.
Yeah, so a lot of sort of, you know, going circles around each other a little bit. Blackwell comes out and says, hey, you know, there are kind of endless reasons that can cause asphyxia. You've sort of negated that asphyxia was a thing here based on your testimony that you just gave. You said it was a heart disease, heart problems caused by or not caused by, but during the restraint by police. And it was also contributed to by methamphetamine and fentanyl. Got it. All right. But you kind of didn't touch on asphyxia at all, or low oxygen. And he holds a book up and says, well, in this book, they say low oxygen and asphyxia can basically happen from anything, right? So a bunch of other stuff. You ruled it out, but there are other ways that you can get there. You don't necessarily have to go your route, is sort of where I think he was going with that line of questioning. Then he comes out and just sort of, you know, sort of smacks that one back and says, yeah, these are complicated, right? There are a lot of different factors that go into somebody's death, which doesn't help the prosecution, because that's exactly what the defense is trying to argue. They're trying to say, yeah, it's not just the knee, folks. A lot of other stuff going on here. Heart disease, maybe COVID, maybe even CO2 getting pumped out of, or carbon monoxide getting pumped out of the vehicle that George Floyd was laying next to. Sort of the first time that we heard that theory, that maybe the carbon monoxide that was being pumped out of the vehicle went into Floyd's body and caused him to not be able to process oxygen. The oxygen won't bind to your red blood cells and won't be carried around to your body because it's being displaced by the carbon monoxide. And interesting theory. Have some conversation about that today as well. But he's walking through this, all these different factors. It's not just the Chauvin knee is what he's saying. Then we get into, now we're going to change gears. We're going to go back over to Eric Nelson, who's asking him about the role of fentanyl. So we have his final conclusion. We have some of the use of force stuff, the knee. What did that do to Floyd's body? Now let's talk about fentanyl and toxicology as the other cause, because this is really the crux of the defense case. Other things killed Floyd, not the knee. So here is Eric Nelson asking Dr. Fowler about the fentanyl and the toxicology and his role as a forensic pathologist in this case.
In terms of the toxicology in this case, how would you characterize the role of fentanyl from the standpoint of forensic pathology? Not toxicology, forensic pathology.
So fentanyl is a powerful narcotic. It's about 80 times more powerful than morphine. And the side effects of fentanyl are slowing down the respiration. So that impairs your ability to breathe as fast as you normally would.
Does that result in decreased oxygen saturation?
It would result in decreased air exchange, which would mean decreasing the oxygen in the bloodstream, but also not fully getting rid of the carbon dioxide, the byproducts of our normal metabolism, so slowly increasing carbon dioxide in his bloodstream.
Now, again, within the context of forensic pathology, what does the presence of norfentanyl mean to you?
Norfentanyl is a byproduct of fentanyl. It's a metabolic byproduct. And so in your liver, or in Mr. Floyd's liver, as the fentanyl passed through the liver, it was broken down into norfentanyl, which is the metabolic byproduct. It's the liver beginning to destroy and metabolize the fentanyl and remove it from the body system.
Now, I'm going to, for the court, there are 3 slides contained within your
All right, so I think we bailed
PowerPoint
out
presentation
on that moment. So you heard him just talk about fentanyl and respiration, and they go through, and he goes through a lot more about the consequences of that. So fentanyl, you just heard him talk about it. It affects respiration, causes the body to essentially need more, to produce more quickly, pump faster in order to get more oxygen, because the blood has less capacity to carry oxygen because it is depressing your respiratory function in your body. So now the blood is having a difficult time carrying the oxygen. What does your body do in response to that? We need more oxygen. So you necessarily sort of breathe harder, but your heart pumps faster. It's trying to get more blood through there, just pumping. If it's 90% shut, you're going to experience an arrhythmia where things are off, because your heart is expecting blood to be in a certain ventricle so that it could push it into a different part of the heart. And if nothing is there, because the blood is not able to make its way through the artery that's 90% clogged, now your heart is trying to function and pump and do things, expecting stuff to be somewhere, and it's not. And it's going faster now because it has low oxygen as a result of the consequences of fentanyl and increased activity, and potentially even the struggle with the police. So the body was naturally responding. Fentanyl made it worse. Heart disease made it worse. Heart goes into overdrive. Blood can't get in. All of these respiratory depressions and heart sort of aggravators, things like methamphetamine, history of heart disease, heart gave out. That's his take on it. Now, here is Mr. Blackwell again coming back out, cross-examining him. I think this is a recross. So it was direct, cross, redirect, recross. And here is Mr. Blackwell now sort of, asking him about the specifics. And again, trying to draw out some questions about his credibility, and sort of pins him down on this 2 pills versus 1 pills thing. So Dr. Fowler thought that there were 2 pills in the back of the police car, in the back of the car, not in George Floyd's car. And here is Mr. Blackwell saying, no, it's just 1, right? So now the jurors go, well, is that a simple little oversight? 1 pill versus 2 pills, kind of inconsequential? Or is this going, this guy doesn't pay any attention to details at all, therefore everything he says is lacking in credibility, right? You can judge for yourself, but here is that exchange.
Dr. Fowler, just for a point of clarification, you've been asked a couple of rounds of questions about the drugs found in Squad 320 to be clear, what we're talking about is one pill, right?
I cannot recall if it's one or two, but it was one of those two numbers, yes.
One partially dissolved pill, right?
I thought it was two, but I stand corrected, Councillor.
And in the back of Squad 320, you didn't see any footage of Mr. Floyd spitting a pill out, did you?
No, I did not.
Now you ask questions about the measurements of the EEL.
All right, so they go into a whole nother line of questioning, but right, 2 pills versus 1 pill. You didn't see him spit it out, but he does acknowledge that there was 1 pill and there was Floyd saliva on it from another testimony, another witness and their testimony. So the jury's going to have to deal with it. We're going to see how that fits, how that stands, but long day of testimony. Let's take a look at some questions over from our locals community. If you want to ask questions and be a part of the show, go to watchingthewatchers.locals.com. Sign up there through your web browser. Join the fun. First one comes from Lassie91, says, apparently there were a lot of things that could have killed George. Is it time for Genevieve Hansen to write a thank you note to Chauvin for not allowing her to work on George? Yeah, probably. Anybody who was involved in that case is going through one right now, right? It seems that whoever was near him at the time he died would be in this unfortunate defendant position. My guess is Genevieve does not realize how lucky she is. I also guess that had she worked on Chauvin and had been accused of murder, Chauvin would have testified for her defense. Interesting. Yeah, interesting observation there, Lassie. And I was thinking about that same concept with Officer Chang, right? He was the one, he was there, he was going to help, and they said, hey, go watch the car. Go watch Floyd's car. Probably the best gift that that guy ever got. National Populist says, what will happen if the jury is hung? Aside from global rioting, I mean. So I'm not real sure that we're going to see a hung jury. If it's a hung jury, it depends on the reason for the hanging. What's going on in that, right? What's sort of the breakdown for the hung jury? I don't think the judge is going to let that happen, though, right? The judge is not going to say you guys are done deliberating on this thing. The judge is going to make them come to a conclusion, and it's going to be unanimous. It might take 6 weeks. I don't think that it will. I really don't. I think they'll come to a conclusion fairly quickly, so I don't expect a hung jury. We have Just Luke says, has the prosecution's credibility been ruined by the fact that they essentially lied to the witness about Chauvin choking Floyd? So yeah, I think Just Luke is referring to an end of the near the end of the testimony today with Dr. Fowler. They were asking him about the choke or about Chauvin being overly aggressive with Floyd during the altercation, right? Remember, they tried to put him in the back of the car, then they tried to pull him out of the back of the car, or he sort of slipped out the other end. There was a lot of back and forth going on. Chauvin was involved in some of that. So one of the lines of questioning was about how he was being overly aggressive before he was even on the ground. So Eric Nelson came back out, played the video, and then asked Dr. Fowler about that and said, hey, does it look like he's strangling him right there? And it's kind of no. It's kind of like a loose little pull, kind of pulling like this, not like this. And so Just Luke, yeah. I mean, I think if you have a situation where you are presenting one idea to the jury and the defense comes out and says, actually, that's not what happened at all, you can take a look at it. Yeah, I think that leaves a mark, and that's what happened today. Mick Waffles in the house says, so both Blackwell and Schlucher are private defense appellate attorneys working the case pro bono and basically running the show, it appears. Could this be causing the state strategy issues? Wondering about your take as a defense attorney. It was really apparent today watching Blackwell. Strategy issues. I'd be curious to see what kind of strategy issues you're pondering about, McWaffle. I don't see any strategy issues right off the top that are ringing a bell. I mean, I think they're running a pretty standard run-of-the-mill prosecution, going through the elements. I'm not seeing how any other sort of external defense attorneys are changing that. Yeah, so I don't know. I need a little bit more clarity before I can comment on that intelligently. Good question, though. Anki Woe says, the prosecution on the last witness today was quite aggressive, even somewhat accusatory and hostile. Was the judge scolding him in the sidebars? It seems as if the last round of his questioning was cut off. Was he told by the judge to stop short because of that? So I also didn't see that either. So that last there was a so two things here. One, the Star Tribune stream I was having problems with today. So it was really choppy. There were something was up with it. So I switched over to the Fox News stream and it was way better. I was trying to watch it this morning in clip and I was missing like 10 seconds. I don't know what was happening, but it was all off. So maybe you saw some of that. If you may have seen something that felt like it was cut off, it may have been that. But when I switched over, I think that Blackwell had his full line of questioning. Yes, though, I do notice your change in tone, or you notice that there was a change in tone. Yeah, they were very aggressive with him. And he was even sort of dialing in on that. It's like, it's a yes or no question. Come on, doctor. Like, this is yes or no. Yes, he starts going off. Yes, yes, yes. So he was a little bit more aggressive, and it wasn't inappropriate, right? That's sort of how cross-examination works. If anything, I think that Eric Nelson maybe was a little bit too deferential towards the law professor. He could have been a little bit more aggressive in shutting him up, but he didn't. And there's probably a good reason for that, right? He wants to, sort of some of cross-examination, you can win, you can sort of slam the ball or spike the ball on a line of questioning and feel good, like you got that point out. But if you look bad doing it, that's not a win for you, right? The jury still thinks you're a jerk and an a-hole, and they're not going to reward you for acting that way. So, there are times when a defense lawyer will say something like, or let me just say, be a lot more deferential, a lot more nice and sort of kind during cross-examination, and people will expect the cross-examination to be like something you see in Hollywood, right? Somebody comes out and isn't it true, and that might look good for the movies, but sometimes that doesn't work well, because if you rub the jurors the wrong way, you can really do more damage to yourself than good. Blaster Brain says, last night, Nelson mentioned a bunch of things to the judge regarding his record keeping of sidebar content. What's the relevance of this, if any? Blackwell struck me as petty when pounding on Fowler for not having considered the weight of the equipment when factoring in the weight upon Floyd. Rather minuscule amount of weight, in my opinion. Yeah, so I agree with this. And I think this was a general theme today. I think that there was a lot of making mountains out of molehills. I think that's the expression going on today. There was Blackwell, who was, aggressive on those things and about like the book and about specific details. Oh, well, this book has a sentence in here that disagrees with you. What do you think about that? It's like petty, kind of marginal minutia BS, sort of like a game of gotcha, but you have to do that, right? That's part of the deal. Blackwell, I think, was just a little bit more obvious than we've seen previously with other witnesses, and even in cross-examination by Eric Nelson against the prosecution witnesses. So it felt a little bit out of place just because stylistically it was a little bit different. And the defense did this also, I think. I mean, they were talking about this carbon monoxide thing, which is a new sort of theory of the case. Hadn't heard that come out thus far. And, that to me sort of felt like, yeah, you got to introduce that because it is reasonable doubt and it is relevant. And obviously it was part of this expert's testimony, but it felt kind of small relative to the other factors, to fentanyl, methamphetamine, heart disease, or Chauvin's knee, right? To any one of those other things. Sort of throwing in carbon monoxide felt like sort of added that later. And both sort of felt a little bit small. We'll be curious to see what the jury thinks about it. Anki Woe says, how do the lawyers find expert witnesses that would most likely support their case without knowing what their testimony will be before they take the stand? So you do sort of a series with expert witnesses. Certainly it doesn't hurt you to have several of them that you've worked with previously. Go through rounds of analysis, and then pick the expert that serves your case best. I mean, really, that's what this boils down to. Sort of sounds bad, right? But yeah, you go and you work with somebody who's going to support your case. Now, it doesn't make sense for you to go out and find an expert witness who's going to lie for you in your case, right? Those expert witnesses, they're not any good. They get skewered on the stand. They have no good reputation because they're seen as being bought and paid for. So you want expert witnesses who have a history of just telling it like it is. And so, yeah, you just say, hey, can you look at this case for me? They review the case. They say, no, yeah, you got nothing here. I mean, like, this is closed and shut. Nothing I'm going to be able to do to help you. Perfect. Thanks. Right. Move on to the next guy. If they have a legitimate opinion, then you can use that expert. So that's what happened here, right? Both. And when you practice long enough, you've worked with enough people that you know who's going to interpret things certain ways. Let's just leave it at that. And you decide to work with those people. And so that's what happened here. Prosecution went to their witnesses, defense went to their witnesses, and we see them both duking it out in court. Spoiler says, do you think the prosecution has played hardball a bit more than the defense? Yes, I think so. After watching them during cross-examination, I feel like Nelson was too easy on the experts. Yeah, and I just sort of commented on that, right? I think that Nelson was actually easier, and I don't know if that was strategic or just stylistic, or maybe he doesn't have, any real desire or belief that he needs to go do those things, right? So it could just be a tactical thing. But yeah, I mean, the prosecution, they're pulling out all the stops, right? They're finding old basketball hooping photos from Floyd's high school days. So yeah, they're going all in. Hack Consulting says, I think it has been a while since Rob showed any kind of slide regarding the prosecution defense arguments, the relative strength of arguing those, and giving a summary of how things look and what should be done for both sides and the judge and the audience to find evidence and present evidence for those arguments. Also, what is the estimated timeline? Defense finishes this week, judge deliberates over the weekend, and then closing arguments on Monday with a conviction decision on Tuesday. So the jury is going to be deliberating. So the judge is not deliberating over the weekend there, Hack Consulting. So the judge is going to be probably thinking about jury instructions and things like that over the weekend. But closing arguments will then start on Monday, and then the jurors deliberate, right? So they're going to be sequestered throughout the rest of the week. And we could get a ruling a judgment, a decision in 5 hours, or it could be 5 days, or it could be 5 weeks. We just don't know, right? So they're going to be sequestered until they come back out with a decision. So it has been a while since we have summarized the arguments, that's for sure. And I will probably do that this weekend, actually. We'll probably, summarize some of this stuff once the defense rests, which is really what I've been waiting for. So we're going to flesh this out, and we'll see what the jury instructions look like, because the jury instructions are so important. They're so important because that's what the jurors are going to be looking at for processing all of this data. They're going to say, we've got all of this data, pages of notes, right? Notebooks full of stuff that they've been writing down over the last 3 weeks, and they're going to have to decipher it. And so the jury instructions tell them how to organize all of that stuff. And so I want to go through the jury instructions once we know what those are, and we'll make arguments for and against, and we'll sort of take all of the evidence that we've been assembling on all of these slides. We have hundreds of slides that we've been accumulating throughout our coverage of the trial, and we'll be able to flesh it all out. But if you have any thoughts on that, any input, I just got an email from one of our doctors who watches the program, like 15 pages of medical notes on Dr. Fowler's testimony today. So you know who you are. You like your anonymity, so I will not out you, but thank you for that. I'm going to look through that. There is so much to go through, and we're almost there. So we are going to get there, Hack Consulting. You better believe it. We got no doubt in the house, as the pretrial discussion included an opportunity for the prosecution to provide a rebuttal witness because Dr. Powell mentioned a prior testimony. How does that work? Does that include limits on what they can present? If they can have a broad range of topics for their case, it seems like it violates the opportunity for the defense to go last. Yeah, so the prosecution goes last. So you get closing arguments, the defense goes, then they get a reclose. So they get, they have the burden of proof. So they get kind of the last bite at the apple. They've got to prove their case, and it's a very high standard traditionally. In practice, legally, it's a high standard. In practice, that has not been my experience. But in this case, yeah, a rebuttal witness. So I don't specifically recall what you're referencing here about Dr. Powell. That's not his name, right? The doctor who testified today mentioning prior testimony. So typically when this happens, and I don't recall seeing this, so don't quote me on this, but it's only limited to the rebuttal witness can come in and only respond to certain particular issues. So they can't bring them back in and say, oh, well, we forgot to mention this about excessive force and about reasonableness and about an objective standard and all those things. And so we're just going to clean all of that up right now. No, it's to rebut a specific point, a specific claim, allegation, or medical conclusion, and that's it. They can't come in and sort of just open the door and opine about anything they want. It's got to be narrowly tailored to the response that is being requested. Good question. Todd Trott says, question for Robert. If found guilty, will there be a great basis for an appeal on No change of venue, possible media influence due to a non-sequestered jury. I'm thinking about Dr. Sam Shepard case as precedent. So I don't remember that case, Todd Trott, but yes, I think so. I mean, I think if Chauvin's acquitted, I think he's going to be appealing all of them, and he's going to have a good basis for it, right? There's really been no other case in recent memory that I can think of where, yes, ordinarily you would say change of venue, ridiculous. Jury sequestration, ridiculous, right? That's just not necessary. We don't need to do that right now. But this case has been wild. Okay, not only do we have a $27 million settlement during jury selection, but we also have another white cop shooting a black person in the middle of the trial, resulting in more protests on a national scale. Everybody's paying attention to this stuff. So it's almost as big of a case as George Floyd. Huge case. And we have the National Guard rolling around. We got curfews being imposed in Minnesota. It's madness. And this trial is just going on like nothing else is happening around the world. Heck, okay, jurors, go home. Don't turn on the TV. Don't read the news. See you tomorrow at 9:30. What? Are you serious? So, yeah, they're going to appeal that. It's going to be a big deal. I think that the courts are going to have to set some rules about this stuff, because right now this is looking problematic. You can make an argument that $27 million settlement, all right, like that's not that big of a deal. The city is on curfew right now. The entire, or at least last night it was, right? Until I think, or maybe the day before that. Whatever, right? It's a big deal. And the jurors live there, and they're having to travel back and forth in between the courthouse and their homes, witnessing all of this stuff going on right there. So, and think about it this way, right? We may not have an immediate basis for an appeal, but let's say we fast forward 6 months from now, 2 years from now, and one of the jurors comes out and says, when they write a book and they say, I wouldn't have done something, but somebody else leaned on me, and there's some indication that there was some ulterior influence. Somebody else was making a decision based on stuff that they heard outside of the trial. In other words, a juror was compromised. Well, what does that do? Now you got post-conviction, you've got all the, appeals, all sorts of stuff. So this thing really can continue forward for the foreseeable future. Good question, Todd Trott. Nadarb Lassir says, do you ever feel like lawyers, prosecutors, judges treat the law and the people they represent as a bit too much of a game? I just don't get what good comes from theatrics when we should be focusing on right versus wrong. Just wondering your thoughts. Very good question, Nadarb. Yeah, so yes, I think that is something that happens. I think that a lot of attorneys, a lot of doctors, a lot of professional people, they become a little bit clinical, right? It becomes just sort of a processing people through the situation. And I know this because somebody is very close to me in my life who actually has to consult with people who are terminally ill from cancer, right? And this person's been doing it for a very long time, right? He's in his 70s. So I have a conversation with him about that. And it's weird to listen to how mechanical he is. I mean, it's almost like a little bit off-putting, because you're going, bro, like you just had to tell a family like they're going to lose their 40-year-old, daughter, and they've got like 6 weeks to live. Like, yeah, just go in and tell them, oh, this is what's happening. Your body's going, kidneys are going to shut down. This is going to shut down, and you're going to be dead in 6 weeks. Anyways, have a nice lunch. I move on to the next room, and you're going, my goodness, like this is crazy. That is, how do you do that? Well, he's been doing it for 30 years. And so you just sort of become accustomed to it. Now, I think that's a natural thing. There are some positives to that, because you can be unemotional, right? If you get overly invested in every single client that comes through your door, you can sort of spiral out of control. Now you're acting emotionally, not logically. Now you're not somebody who's thinking through the legal issues. You're sort of invested into treating this person, like a human being, which they are. But if you're too invested in that, if you're too emotionally connected with this person, maybe you're not thinking right or making the best decisions for them. And so you have to be a little bit disconnected from it as well. So there are a lot of positives to it. That being said, there are a lot of other good lawyers out there who maintain their connection to the people that they serve, something that we try to do here at the office. I'm personally involved in a lot of stuff like that, as are a lot of the people here. A big part of my life is about sobriety, about recovery and addiction, and about being of service to people. And so that keeps me pretty plugged in to a lot of the people that we work with on a regular basis, people who are facing criminal charges due to drugs and alcohol and that type of stuff. And so I personally try not to lose focus of it. We orient our firm around that, right? We say, what are our 3 pillars here? Safety, clarity, and hope. For who? For the clients, right? Not for us. Okay, we need to help those people get that safety, clarity, and hope in their cases and in their lives. So, yes, I think it can be clinical, but we all need to pause and just stop and say, hey, these are real lives we're talking about. And I want to hit this point home, so I'm going to save this on our next segment. Nadarb, you're one step ahead of me. We got Norovira says, hey, Norovira, there she is, says, norfentanyl was a bad question. You can have norfentanyl, then take more fentanyl and have both, with fentanyl being absorbed within 10 to 15 minutes, sometimes 5 minutes. And I agree with that. I thought it wasn't the best question. And he didn't have a good follow-up on this. So Nelson asked him about this, said, okay, well, there's fentanyl in the blood, right? And there was norfentanyl in the blood. What does the norfentanyl mean? Well, it means the body was processing the fentanyl, it was metabolizing the fentanyl, resulting in the norfentanyl. Got it. But that doesn't comport with the last-minute ingestion theory. It just kind of made it sound like, yeah, maybe he took fentanyl at 3 hours ago and his body was already processing it. So Nelson didn't get to ask him about, at least in the segment that I was watching, about whether that would preclude this last minute ingestion theory, which would spike the active fentanyl, but not the norfentanyl. So you would see sort of a differential relationship there. And I didn't see that really get dug into too much. Hack Consulting says, at this point, what things would be great to take on appeals court or claim mistrial? So you'd have to see something pretty catastrophic with the jurors. You'd have to be the jurors doing something very, very improper, or one of the defense attorneys or somebody doing something improper. Like it has to be I would say it would have to be within the trial. Somebody would have to be doing something very inappropriate. And I don't even want to speculate about what that might be, because the possibilities there are endless. But appeals is a different concept, right? You can appeal something you would think would be legal error. I mean, you could appeal the ruling about keeping Morries Hall out. You could appeal any one of those decisions and say this was the basis for the appeal. So there are a lot of options. It's kind of hard to speculate because it's such a broad question, but it's a good one. Pinky number 2 in the house says, question, I still get hung up on Chauvin being on his shoulder so long. What is your opinion? He had him down. He was stressed. People telling the officer he was no longer fighting. What is the benefit to keeping him down and not cuffing him and putting him in the car sooner? So I'll respond with what the defense I think is presenting. And we haven't really heard much of this yet, but I think the defense argument is going to be that Chauvin felt fearful of the crowd. And it's again, this prioritization question. We've seen a lot of this. We've seen a lot of different people who arrived on scene also conclude that it was a dangerous situation. We heard that from the paramedics, 2 of them. We heard that from Officer Chang, who said yesterday that the crowd was aggressive and he felt concerned for the officer's safety, I think almost verbatim. And so Chauvin is going to sort of adopt that same posture. He's going to say, whether he takes a stand or not, the closing argument is going to be that the police have to prioritize certain actions. If the police are in a situation where they are feeling threatened or their life is in danger or the lives of their partners, their fellow officers, then those have to be prioritized first. And that includes protecting and securing the scene against hostile activity. So that would mean that rolling Floyd over and starting to administer CPR would necessarily put Chauvin and those other officers in a vulnerable position, right? Because now they're not alert anymore. They're not on guard. They're not looking around, controlling a suspect. They're observing their surroundings. If they started to act on Floyd before the paramedics arrived, they would have to necessarily give up that posture in order to start administering aid. If they feel like they're under threat or duress from the crowd, then they would not make that conclusion. They would not make that change. And I think that is really the only argument that they have as to that effect. And I think some expert witnesses, the guy yesterday, Brode, kind of supports that. So I understand your perspective, and we've talked about this previously on the show, Pinky, and I think we talked about it over on Clubhouse recently. And Ma actually brought this up, this point. Yes, maybe there are legal standards. Maybe there are certain things that are legally sufficient and they're justifiable in a court of law, but people, this case is about people, and it's kind of like what Nadar was saying, right? It can be very technical. We can be very mechanical with this stuff. Yeah, we can say arteriosclerosis 100 times until we're blue in the face, but it's about people, and people saw what they saw. They saw the Chauvin's knee on Floyd's neck, and it doesn't sit well with people. And so people are asking the same question like you, Pinky. They're saying, hey, why didn't he do something about that? because it doesn't feel right. Could be CO2, carbon monoxide, could be arteriosclerosis, fentanyl, methamphetamines, whatever. But how do you explain that? We're going to see what the jury has to say about it. We've got chairman of the board. So if they determine that it was the combination of events that killed Floyd, and he likely wouldn't have died without the drugs, but also wouldn't have died without the police actions, is that reasonable doubt because the police wouldn't have killed him had it not been for the other factors? Yeah, so I think what you're asking for, chairman of the board, is you're trying to identify the but-for cause. If we know we have a number of different variables in this whole equation. Floyd's dead. Bunch of things happened. Could these things have killed Floyd? And we start pulling out different variables, right? And Nelson did this with one of the expert witnesses. I think it was, she was a female doctor, older woman, a couple weeks ago. She's on our slide somewhere. Anyways, he was going through the list and he said, all right, listen, if you showed up at somebody's apartment and they were dead inside and they had 11 nanograms per milliliter of fentanyl in there, would you consider that to be sufficient? That alone, would that get you to a cause of death? Yes, it would. What if you saw somebody that had 90% blockage in one of their arteries in their heart? Would that be sufficient to get you to a justifiable cause of death? In other words, would you stop looking if you saw that for a cause of death? Yes, we would. So you have all of these different factors, and they're all sort of layering on top of one another. So what you're trying to identify, Chairman, is the but-for cause. What is the one thing that we know is a variable that if we take that out, George Floyd would not have died? Government says it was the knee. Looking like the defense is saying it was the heart. Your question, he wouldn't have died without the drugs, but also wouldn't have died without the police actions. Is that reasonable doubt? You're going to have to weigh the credibility of the experts. You have competing viewpoints for the cause of death. One of the government's own experts more closely agrees with the defense cause of death. To me, that sounds like reasonable doubt all day. McWaffle says, Blackwell, establishing reasonable doubt about Floyd taking opiates. Did you see Floyd spit out a pill in the police car? We know the pill was there. Floyd isn't on trial. They have been on the back foot, in essence, creating reasonable doubt for the issues surrounding Floyd. Why Nelson's job was a little easier during their case, I don't know. Did you see Floyd spit out a pill? Yeah. I mean, he's acknowledging, right, that there was a pill. And we saw that there was testimony about saliva on that pill, right? Saliva and Floyd DNA. I'm not making that up. Liberty or Death says, any thoughts on who has presented a better case? So right out off, from a gut perspective, the prosecution, I think, without any question of a doubt. Prosecution has a better style, a lot more provocative, a lot more emotional, very much using demonstrative evidence, beautiful PowerPoints, video, 3D renderings, charts, graphs, arrows, all sorts of, the production value, I think, was way better than the defense. And it should be, right? It's their case. They have something like 10 different attorneys working on the case that are officially on the case. I know Nelson is part of a bigger firm, but I'm not sure what sort of resources he has. So they've got all of these people from all over the country just sort of piling in. I think their presentation has been clearly better. Now we have the next question. Was Nelson's motion to acquit the same as an attorney would file a Rule 50A motion at the end of a plaintiff presenting evidence than a 50B after a jury verdict? So if you're talking about civil rules, I don't know. In Arizona, we call it Rule 20. So it's a rule of criminal procedure. Okay. Judgment is a matter of law. So again, yeah, that's not my area. So, we in Arizona, we have a rule that is very similar to what they have in Minnesota. And it's basically after the state presents their case, we just move. We say, look, they've got the burden of proof, which they're going to prove at the end of trial, but they've got the burden of production. They have to bring enough material into court in order to justify their case. And we've heard everything that they have. They don't have anything. So we're going to move for a judgment of acquittal. And it's almost just a procedural thing. Now, almost every single time, very rarely does a judge go, you know what? You're right. I haven't heard of anything. I had a bench trial one time, I think early in my career, where I was doing I'll give you an example of this. So this was a criminal speeding trial that I did really early in my career. It's a criminal charge in Arizona. It's a misdemeanor, same category as a DUI. And it's a very common offense. A lot of people get this. They don't want criminal convictions on their records. They hire a lawyer to go do it. I did this trial one time, and I moved for a judgment of acquittal, essentially, is what it is. And the way that it worked is the officer was presenting their evidence. I think that so long ago, I'm trying to remember correctly. Officer was presenting the evidence. I think I told this story once before, but the officer and the prosecutor forgot to mention identification. So they just glossed over ID, right? They couldn't identify the person who was driving the car. So they presented a ton of evidence, going this fast, driving like a maniac. This was a young kid who was doing X, Y, and Z. We know that he was 25, blah, 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 right? Got him on radar, going up, down the I-17, whatever. Kid was like dead to rights. But the government missed identifying the kid. They didn't say anything about it. So I don't know who the hell they were talking about that day. Sure as hell wasn't our client though, but they were going through and all this evidence, and I just, okay, Judge, they presented a nice case. Whoever they talked about there sounds like he's in deep trouble, but they didn't identify my client, right? Not here, no idea who the hell they're talking about. So even if everything they said was true in their case, the judge could not fine for them because they missed a pretty key element, which was ID. So that was a not guilty verdict. That was a pretty good win. Pretty good win. The prosecutor was not happy about that. I like to shake hands after, not anymore because it's COVID and nobody's doing trials, but I like to shake hands after the end of a trial like that. Just say, hey, thanks for showing up. I know we're both here. We're both trying to, articulate for our sides. Sometimes these things don't work out. Try to shake a hand. Didn't happen. No. Stormed right out of the courtroom. But that's okay. That's okay. That's just how these things work. Good questions. We got Bessa Miento says, Blackwell's questioning sounded very puerile to me, not at all knowledgeable, believable, or sophisticated. Yeah, it's funny. We're getting a lot of those comments today. So it wasn't just me, right? He did sound almost a little, I don't want to use the word childish, but a little bit childish, kind of petty, kind of bickering over a lot of the same stuff. Nelson didn't do that to their witnesses, right? He was sort of a little bit easier going with them. And so sometimes that stuff rubs the jurors the wrong way, but I don't know. We've got _shades says, what about the gum? It was all over Twitter today. They said it was gum in his mouth. Okay, it could have been. Or it could have been the pill that was found in the back of the car that has saliva and DNA on it. I don't know. Could be one or the other. Did they find gum? Did that come out in court today? Did I miss that? Was there gum today? I could have missed that. I'm serious. I could have missed it. Norovirus said, I said this above. The city is so sorry they agreed to $27 million now. What are they going to do for this weekend shooting? And what about the next weekend? They're going to run out of money. They are, yeah. $27 million to Floyd, another $27 million to the Wright family. Probably going to be another one soon. So we're going to be looking at close to $100 million here pretty soon. That city's going to have to do something to generate those funds that they feel are warranted to give out. We got Todd Trout says Dr. Sam Shepard case is what the TV series and the movie The Fugitive was based on. Oh, cool. I didn't know that. He wrongfully got convicted for murdering his wife in the 1950s. Media convicted him by influencing the jury. Wow, I didn't know that. Harrison Ford. I didn't kill my wife. Tommy Lee Jones. I don't care. Jumps out of the chute. Good movie. Maybe I'll watch that this weekend. Good questions. All right, so we got Hack Consulting in the house says, I think that the new riot will lessen the June stuff on regards of the jury. Regardless of what the jury does, there will be rioting. Nothing is in connection to reality, and especially since there has not been too much immediate coverage of the Chauvin trial, they can still get relevant information about the Dante riots to stay safe. Plus, the government is responsible for their lives. Otherwise, we riot. No riots. No riots, Hack Consulting. No. Peaceful. Peace and love and harmony and unity. Joe Biden's in office now. Joe Biden. We're all one. Love America. We got Blaster Brain says, you glossed over part one of my earlier question. What's the deal with Nelson bringing up his record keeping of the content of sidebars after the jury left? Will you be a lamb and let me know? You don't have to bleat, but I would prefer it. So I apologize, Blaster Brain. I didn't realize that. I get a little bit caught up in sort of the momentum here and I get carried away. I don't actually know what you're talking about. What's the deal with Nelson bringing up record keeping of the content of sidebars after the jury left? So I watched the end of the testimony today, but I didn't see that. So I'm not sure what he could be bringing up. I mean, I would imagine that all of that stuff is being logged, right? Because they have a court reporter who is noting those things. So I'm not sure what Nelson would be record keeping. I'm not sure what he would be gathering in order to communicate to the court. Maybe he sees a pattern about something. You know, you're sustaining their objections, but not my objections. Want some clarity about that. Who knows? We've got Ma Fox says, come on, the people yelling about cops not administering aid were going to become more violent upon rendering aid. Blah. Yeah. So that's the converse argument, right? That if they would have helped, that would have saved his life, not caused the crowd to be more violent, because they were doing what the crowd was screaming at them to do, right? Check his pulse, give him CPR, all that stuff. If the cops start doing that, what happens? Does the crowd now say, you're checking his pulse too hard? Or you should be rendering more aid and we're going to beat you up now? No, right? I think what Ma is saying is that it would sort of lessen the tension, and that excuse from Chauvin that we needed to maintain our defensive posture doesn't carry any water with Ma Fox. We have NY Renal MD says, I watched a portion of the pathologist testimony today. It was meh. The only thing I think was convincing was his accent.